Chapter 10. Alternative Dispute Resolution, ADR. Outside sources are underlined in blue text. Forms available in our Forms package are underlined in red text. Links to each are below this video. Alternative Dispute Resolution, commonly known as ADR, is referred to as the contemporary legal platform for savvy people to resolve disputes. Why is that? ADR methods, marked by their collaborative and non-adversarial nature, have proven to be more efficient alternatives to combat-style courtroom litigation. ADR provides improved results and does it more efficiently, economically, and expeditiously than the costly, stressful, and time-consuming court system. It provides solutions, not adversarial confrontation. It's as simple as that. ADR addresses civil disputes outside of the court system to settle disputes with mediation or provide a final judgment without appeal rights with arbitration. Its acronym ADR stands for A equals alternative equals outside of the public court system. D equals dispute equals a civil dispute that can be remedied by the payment of money or enforcement of an obligation. R equals resolution equals by settlement or judgment, without appeal rights. Where does ADR fit into the legal system? As mentioned before, we have two civil legal systems in the United States: the public court system that anyone with a dispute can enter, and a private system called Alternative Dispute Resolution that requires the written consent of all parties to enter. This chapter focuses on the private, or alternative as it is called, dispute resolution system. Why did this private, alternative system emerge? This issue was referenced in the legal self-help chapter, but let's circle back to why these important alternatives emerged as answers to our struggling court system and its warrior demeanor. This involves stepping into the House of Horrors, also known as the upper civil courts. In the public court system, each dispute starts as an emotional tug-of-war between two or more parties. They haven't tried or haven't been able to resolve their dispute, so they hire attorneys to bring it to court thinking this is their only option. Yes, it is the only option if you are looking for complexity, expense, and stress in the House of Horrors. Their goal in bringing counsel on board is to terminate the dispute. However, at this point their dispute typically veers out of control, both emotionally and financially. Egos take over. You're fed up and you're going to make your opponent pay. Little do you realize that, in the long run, it is you who pays. Your opponent feels the same way, but only in retrospect. Your respective attorneys jump on the adversarial bandwagon. For them, it becomes a battle of wits. Who plays the game better? Emotions become highly charged. Egos rule. Paper generates. Calendars fill up. Expenses soar. And it just keeps going as it proceeds into litigation frenzy mode through the House of Horrors. This is just how it goes. Just as medical doctors are trained to address a medical issue with medication or surgery, trial lawyers are trained to do battle. The litigation frenzy. By the time you get to trial, you're drained from the litigation frenzy. You've answered too many interrogatories, produced too many documents, responded to too many questions at deposition. The enormous amount of data generated is difficult and expensive to manage. You've spent way too much time in this conundrum, which has reached humongous proportions. As the litigation frenzy takes hold, it becomes virtually impossible to tap any humane meaning from the increasingly adversarial nature of litigation. At trial, it all begins again. Emotionally, you're depleted. Financially, what was once your nest egg is used by your attorney to conduct the battle. Enter the House of Horrors and you will see why. You shuffle into a courtroom to occupy the plaintiff or defendant table, placed at floor level to trigger a feeling of intimidation. Look up at a judge perched far above on a majestic throne, wearing a robe to signify his importance, and many jurors who avoided imprisonment by showing up, elevated above floor level, stared down by the bailiff with a gun, who somehow is missing in this drawing but is present in every courtroom, your every word typed by the court reporter at a very expensive price. This is the way of the House of Horrors. This scene, the culmination of years of attorneys and parties battling one another, is the trial of a case which began as a simple set of facts and through the litigation frenzy evolved into a drama of immense proportions. And this may not be the last courtroom for this case, as the parties have the right to appeal the result and move the case into yet another forum, the Court of Appeals, where it begins all over again. This is the climate that prompted poet Robert Frost to comment. A jury consists of 12 persons chosen to decide who has the better lawyer. Even if you did have the better lawyer, or at least you had more money to pay for one, you feel drained and ripped off by your trial win. When it's over, the disputing warriors become humans again as they shed their armor. They sit in the courtroom, winners and losers, able to think rationally and breathe again for the first time since the battle began years ago. But not for long, as they recognize there might be yet a second round in the even more costly Court of Appeals. They ask themselves, was all the time, money, and energy worth it? Usually, the answer is a resounding no, even for those who prevailed at trial. It took too long, it cost too much, and the emotional commitment was exhausting. You can see why in virtually every part of our country, the legal process beyond small claims court is far too complicated and combative for your average person to access without an attorney, and too expensive with an attorney. Even with a contingent fee arrangement, you lose 40% of your damages and pay numerous costs as the litigation frenzy takes over. The emergence of a private dispute resolution system. There's got to be a better way, is the mindset that often results in new and better systems. In this instance, it was alternative dispute resolution. And the better way got even better with no appeal rights. Mediated settlement with a track record of 85%. A platform you can customize with many different options such as no attorney representation, limited hearing duration, and much more. An informal atmosphere. Online dispute resolution. You retort, I don't have an ADR agreement with my opponent, so I'm stuck with the House of Horrors. Think again. Explore the many ADR options available for your dispute and decide which you want to adopt. Choose one of our ADR agreements with customization options and send it to your adversary with our ADR transmittal letter form. If you include this chapter for their edification, you will likely soon find out that your adversary feels the same way about what lies ahead. It's all about recognizing the many pitfalls of the House of Horrors and intelligently detouring into ADR, making the court system the enemy, not one another. Then, wisely acknowledging that there is a road ahead to resolve your dispute and recommending a smarter, more civil way to do it. Disputing parties in the know and disillusioned with the court system can turn it around with ADR if they understand its many advantages. It's a new way of law with a brand new sense of fairness for modern folks. With many alternatives at their fingertips, disputants now respond with a more proactive demeanor. They are interested in looking at their range of options outside of the court system. Their mantra becomes, don't litigate, mitigate. Instead of feeling overwhelmed and fearful, they decide to mitigate instead of litigate, feeling in charge and ready to incorporate resources to find a meaningful solution. For them, the advantages of ADR significantly outweigh the potential disasters that lie ahead in the House of Horrors. The difference between courts and ADR. ADR is user-friendly. There is a multitude of reasons why ADR is a wise way to resolve your legal dispute. One of the top reasons is ADR is user-friendly, especially with the increasing popularity of online platforms where you don't need to fight traffic or face your adversary in person, and with the many ways to customize your ADR proceeding. Although the upper civil courts, as opposed to the small claims courts, continue to be too complex for average folks to represent themselves, ADR was built to be available to the DIY hands-on legal consumer. In user-friendly ADR, rigid and complex rules required in the court system are abbreviated or discarded. Less formality. Instead of a judge and jury, an attorney with experience in your type of dispute assists you and your disputing party to reach a resolution, whether by settlement in mediation or by judgment in arbitration. It's far more relaxed than shuffling into the courtroom depicted above. ADR is the antithesis of the courtroom. With in-person ADR, everyone sits at the same level at one table, coffee and water are served, and everyone is equal. The rules are abbreviated and most often just left to the parties to customize and the mediator/arbitrator to apply. Online, it's even more hospitable and convenient as it takes place from wherever you are. Types of alternative dispute resolution. As society becomes more technology-based, so does dispute resolution in its varied formats. The most popular ADR processes include mediation, online or in person; arbitration, online, in person or document only; online mediation and arbitration. There are two ways to participate in audiovisual ADR: in person with the parties present all together in person, and online with the parties present online. There is also a hybrid process where some parties are personally present and some are online, or some of the proceedings are online and others are in person. The mediator or arbitrator typically chooses a hybrid as a workaround. The COVID-19 pandemic impacted not only the way we live and do business but also how legal disputes are resolved. The need to avoid in-person contact forced disputing parties to seriously embrace new or vastly improved ADR platforms such as online ADR and document-only arbitration. It worked big time. Nowadays, our disputes have more modern solutions with impersonal, technology-based platforms, making ADR far more convenient and accessible. The evolution of alternative dispute resolution, ADR, into online dispute resolution, ODR, represents a significant advancement in the field of conflict resolution. The introduction of ODR, spurred by the rise of digital interactions, has further expedited dispute resolution by leveraging technology and online platforms. These new online platforms are described in a 2-minute video on this website: Judicial Arbitration and Mediation, JAMS. Let's review some of the advantages and disadvantages of online dispute resolution so you can make the best choice for your proceeding. ODR's advantages. Many advantages to ODR over traditional ADR have become apparent as the ODR system has evolved. ODR was necessary amidst the pandemic. Many dispute resolution providers required only fully vaccinated parties with proof of vaccinations to access in-person ADR. With ODR, the entire dispute resolution process can occur online, or a hybrid process can be utilized whereby part of the process is in person and part is online. ODR is convenient. People are busy. They don't have the time to drop the important responsibilities of their daily lives and battle traffic to arrive at a location and devote an entire day or week to resolving their dispute. ODR is less adversarial. Nobody likes the adversity that comes with meeting in person with an opponent. Emotions and stress take over and the atmosphere naturally becomes combative. The online platform provides the separation necessary to allow parties to operate from a more relaxed, unemotional, less stressful platform. ODR is more equitable. A user's socioeconomic status becomes almost irrelevant with ODR's equal access. The less advantaged and those unable to take time off work can fully participate. ODR is accessible. ODR allows parties with internet access to file a claim and resolve cases from anywhere and at any time of the day or night. Many disputes that would not otherwise be heard are now being resolved online. ODR is less complex. Disputing parties are no longer interested in adhering to traditional rules that require costly attorney representation to be understood. ODR rules have been siphoned down to make the dispute resolution process streamlined and layperson-friendly. ODR is more expeditious and less expensive. ODR's information management is aided by computers and software which cause the process to be more direct and platform regulated. The result is a faster, more efficient, less expensive process. ODR's disadvantages. Building of rapport. The online mediator/arbitrator encounters difficulty building rapport with parties, especially in mediation. Creating an atmosphere in which the parties trust the mediator to help them resolve their dispute is considered vital. Cyber mediation loses the dynamics of in-person mediation because it takes place at a distance and in front of computer screens, rather than face-to-face. Reading body language. In both mediation and arbitration, reading body language is important. Online, it is quite challenging to do so. Empathy too and human insight, important in both mediation and arbitration, is hard to grasp when cyberspace is the platform. Those who are not tech-savvy. Online access may pose a problem for some individuals. Continuous internet access for the length of time it takes to resolve a dispute, which may be hours, days, and possibly weeks for complex matters, may also pose a problem for those with limited access. It may also disadvantage those who are less familiar with online technology. Difficulty tracking. It can be difficult to piece it all together when done in cyberspace. The mediator/arbitrator needs to implement appropriate staging, so they and the participants can cohesively understand the whole picture. A complex case that is already convoluted would be more difficult to present online. Rule adherence. Parties and their counsel have a higher tendency to operate outside of the rules when not present under the personal scrutiny of the mediator/arbitrator, who must continually monitor and correct. Online mediation and arbitration are further addressed in the mediation and arbitration chapters of this course. Smart cookie tip. If your ADR agreement includes both mediation and arbitration, you can always choose in person for one and online for the other. Document-only arbitration, DOA. Document-only arbitration, DOA, is the same as other arbitration proceedings, it just excludes oral hearings. Like online proceedings, the document-only process was infrequently used before the COVID-19 pandemic, during which we became more technology-based and needing to avoid in-person proceedings. This atmosphere opened a whole new paradigm for alternative dispute resolution, document-only proceedings with it. These written documents may include contracts between the parties, declarations of parties and witnesses made under penalty of perjury, memoranda of points of law, and other evidentiary submissions. The rules of the arbitration will provide you with guidelines defining the documents permitted. These proceedings, which exclude the audiovisual element, streamline the proceedings considerably and make room for the self-represented party to step up to the bar. Mid to low-value cases are prime for DOA. Some ADR providers sort their arbitration cases by value, where those valued at $75,000 or less follow expedited rules, and those valued at $25,000 or less are routed to a document-only format. Smart cookie tip. You and your adversary can opt for expedited rules or document-only arbitration whether or not your case falls into these designations. Mediation, arbitration providers. There are many ADR providers, including long-standing frontrunners such as Judicial Arbitration and Mediation, JAMS, and the American Arbitration Association. Perform an internet search of mediation, arbitration providers to locate more. Customizing your ADR proceeding. It's your dispute outside of the rigid court system in the land of all things possible. When you signed up for ADR, you took an important step, but don't stop there. Customize your proceedings with choices that will streamline the process and propel you to the finish line in a constructive way. If you have an existing ADR provision or agreement, you can customize it also, if all parties agree. Below are some provisions to consider. Your creative mind can come up with many more. First, engage in automated online blind bidding. Engage in mediation before arbitration. Choice of mediation provider. Choice of arbitration provider. The parties will be self-represented at mediation. The parties will be self-represented at arbitration. The proceedings will be limited in duration. The arbitration proceedings will be 1. Document only. 2. Entirely online. 3. Entirely in person. 4. A hybrid of 2 and 3 at the arbitrator's option. The mediation proceedings will be entirely online, entirely in person, hybrid. At arbitration, the winning party will pay the loser's attorney fees and costs. At arbitration, the winning party will pay the arbitrator fees, including administration fees. At arbitration, there will be limited or no discovery. At arbitration, revising the rules of the arbitration provider. And so forth. Let's explore each option. Automated online blind bidding precedes all other ADR procedures. Prior to any other alternative dispute resolution procedures, the parties agree to proceed to automated online blind bidding. This platform was described in the settlement chapter. Engage in mediation before arbitration. Why take your dispute into the arbitration arena where a judgment will be imposed when it can very likely be resolved at mediation, which has an 85% success rate? Choose the mediation and/or arbitration provider. There are many ADR providers, including long-standing front-runners such as Judicial Arbitration and Mediation, JAMS, and the American Arbitration Association, AAA, and a multitude of newer providers with more expedited proceedings. Perform an internet search of mediation arbitration providers to locate more. Review their rules on their website. Make sure they are concise and clear. Name your provider and the neutral arbitrator that will preside in your agreement. The parties will be self-represented. How would you like to get it over with without attorneys? With a mediator or arbitrator, you have an attorney. Perhaps hiring your own is redundant. Smart cookie tip. Consider self-representing at mediation, where you really can't botch things up because all information gained there is confidential, and if it doesn't resolve there, consider hiring an attorney for arbitration. Think it through. Limit the duration of the proceedings. ADR, especially arbitration, can expand into full-blown mini-trials unless contained. Limiting the duration of the proceedings requires the parties and the mediator-arbitrator to use the time wisely. Remember, the reason you are in ADR is to get it over with soon and with minimum expense and stress. Smart cookie tip. Make sure the mediator-arbitrator apportions the time evenly, understanding their job to also be a time balancer between the parties. Specify that the proceedings are online, in person or hybrid, or document only. If an ADR agreement specifies mediation and/or arbitration as your dispute resolution forum, any of these options are available to you. But, if the provision does not specify which, the choice will be up to the disputing parties, which is never ideal. It is best to make this choice in the agreement itself or an addendum. If there is no choice, a pre-hearing session with the mediator or arbitrator can be set up to prompt the parties. At arbitration, the winning party will pay the loser's attorney fees and costs. Assuming you do not already have a written agreement that covers this, now is the time to consider the subject. Even if an existing agreement does include this provision, it can be revised or removed with all parties' agreement. The parties need to feel they each have a good case or defense to agree to a provision like this now. Losing a case and having to pay your adversary's costs to fight you can be a very challenging blow both to the ego and the pocketbook. Assess exposure very carefully. Smart cookie tip. You can also tailor your provision to limit exposure, such as up to a max of a certain dollar amount. At arbitration, the winning party will pay the arbitration fees. If you have not limited the duration of the arbitration, you could face a sizable sum here, likely much less than attorney fees, but still, something to carefully assess. At arbitration, there will be limited or no discovery. This is something very important but difficult for a layperson to assess. You might want to consult with someone in the legal loop regarding the subject of discovery. Smart cookie tip. There are online and in-person paralegals that can guide you less expensively than an attorney, and often they are much more available. Online platforms, such as Freelancer.com, Fiverr.com, Upwork.com, JustAnswer.com, have paralegals and attorneys you can consult with. The arbitration and upper civil courts chapters delve more deeply into this very important provision. In arbitration, revising the rules of the arbitration provider. Read the rules of the arbitration provider selected. With the agreement of all parties, some of those rules can be revised. Other customizations. There are many other customizations you can adopt for your proceeding. Take the time to set the stage for your ADR proceeding instead of blindly walking into the forum without considering the many options available. If you already have an ADR agreement and it does not include these options, if all parties agree, they can be added now with our options addendum to ADR agreement form. If you have an attorney, seriously discuss these options. If not, consult with a legal professional to make your best choices. Proposing ADR to your adversary. Now that you understand the ADR platform for your dispute and your customization options, choose the ADR agreement that best conforms to your choice in our forms package. Options addendum to ADR agreement. Customizing an existing agreement. Mediation. Parties agree to mediate. Arbitration. Parties agree to arbitrate. Mediation arbitration. Parties agree to mediate, and if unsuccessful, to arbitrate. Multi-step ADR. Parties agree to first engage in online blind bidding, then mediate small claims if within that jurisdiction, if not arbitrate. Use our ADR transmittal letter form to transmit the ADR form of your choice to your opponent. You might also want to include a copy of this chapter or a link to our ADR webpage. Hopefully, you have discovered that the answer to your legal dispute is to avoid the House of Horrors at all costs and instead detour to the House of Resolution. You can do it. It's called smart, empowered, proactive.